strangling Madeline, John, and Robin, and then taking their bodies and moving them to the storage unit.
According to Waters, inside the storage unit, Carr cut the O'Hares into pieces so they'd fit into 55-gallon drums.
Waters claims Danny Fry was shot by Carr on September 30th, then mutilated so he'd be difficult to identify.
After the FBI threatens to withdraw the plea deal, however, Waters eventually admits that he killed Fry and that it was part of his plan all along.
Waters says he lured Danny Fry to the banks of the Trinity River, then shot him in the back of the head.
Waters sticks to his account, adding only that Carr butchered Fry on the riverbank.
Fry's head, hands, and clothes were put in a bag and then driven back to Austin and subsequently disposed.
Camp Wood, Texas, Saturday, January 27, 2001. David Waters leads investigators to Cooksey Ranch, the same place Carr sent them almost 2 years earlier.
This time, investigators locate a shallow grave. After 20 hours of digging, they unearth 3 sets of human remains.
The skulls are intact and wrapped in plastic. The legs have been completely severed. The serial number of an artificial hip bone matches Madeline Murray O'Hare's.
Eventually, dig teams discovered a 4th set of remains consisting of a skull and 2 hands, which belonged to Danny Fry.
Using medical and dental records, law enforcement soon confirms the remains are Madeline and Robin Murray O'Hare, John Murray, and Danny Fry.
Given Waters' statement and the fact that the plastic bags are found around the heads, asphyxiation is the suspected cause of death.
Despite his confession and the trail of bodies left scattered across Texas, David Waters is never charged with the murders of Danny Fry or the O'Hares.
For extorting the $600,000 from the O'Hares, Waters ultimately gets an additional 20 years added to the 60-year sentence he's already serving.
Well, dirtbags are dirtbags, and when you get a bunch of bad guys together and they hatch all these ridiculous plots and it's all over money, it goes terribly south on you.
And the Associate Justices of the Supreme Court of the United States.
The Supreme Court hears oral arguments today on the Boston bomber case. At stake whether Dzhokhar Tsarnaev deserves the death penalty. We'll listen to those arguments live. As jury selection inches closer in the Ahmaud Arbery trial, 1,000 people in Glynn County, Georgia, are in the pool, all told to answer an extensive questionnaire. Plus,
we hereby find the cause and manner of death to be the cause, death by strangulation, and manner is homicide.
more reaction this morning as the coroner reveals disturbing details about the death of Gabby Petito. Meanwhile, the search continues for Brian Laundrie. We'll have his family attorney's reaction. It's all next on Court TV Live. Good morning. Welcome to Court TV Live. I'm Ted Rollins. Happy to have you along with us this morning. The Supreme Court justices are set to hear oral arguments in about an hour from now. They will be reviewing a lower court opinion that wiped away the death sentence for Boston Marathon bomber Dzhokhar Tsarnaev. He was originally sentenced to death in 2015. 3 spectators and a police officer were killed in the 2013 bombing, which Tsarnaev planned and executed with his brother, who ended up dying in a gunfight with police. A federal appeals court ruled that Tsarnaev should be given a new penalty phase trial because of issues with jury selection and pretrial publicity. Joining us to talk about it, Kira Lynn Abernathy. She's a criminal defense attorney in Atlanta, Georgia, and trial attorney, civil rights attorney Richard St. Paul. He's in New York City. Good morning to both of you. Kira Lynn, to you. This is, one of those cases where you're thinking, really, why would the federal government overturn that? It seemed to be overwhelming in the evidence, and the jury came to a conclusion. But there were some issues in this case, and it surrounded around the decision by the trial attorney to say no, first of all, to the change of venue. And that's the beginning of what created issues with then juror misconduct, which is alleged by the defense and upheld by the Court of Appeals. Basically, the ruling was these jurors were dishonest during voir dire, and there was social media evidence that they were dishonest. This should have been moved. The Timothy McVeigh Oklahoma City bombing case was moved. There was precedent for it. They took that case to Denver. Why not move it out of Massachusetts? So, Kira, first to you. For someone who's thinking, oh, this is a big waste of time to have this case of all cases in front of the Supreme Court, it's not about the bombing. It's about what happened afterwards.
Absolutely. It is about us being able to uphold our justice system and to be able to preserve the rights for future cases prior. Yes, this case has a lot of media coverage. Yes, it was huge and impacted a lot, which is probably why it was able to be pushed through to the Supreme Court, because they want to see things that are very clear cut. They want to be able to see things, okay, is there a law here that we need to address? Is there some issues? Is there, some specific items that we need to look at and make law very clear for the rest of the country to say, hey, this is how it's going to be moving forward. So it's very technical in nature, but it is, to me, not a waste of time. And I'm interested to see, what they say, what the Supremes have to say about this.
Richard, your just initial thoughts on where we are now in this case and what you think the court is really going to be honing in on.
Well, look, the court is very much interested, as the First Circuit, which overturned the lower court's ruling, in fair and justice that is fair and not prejudicial. And when you're not allowed, and many times, actually all the time, when I'm in court and doing voir dire, I'm asking jurors, do they know about these cases? In particular cases, or have they read about them? Cases that have been in the media or have been in the news. I'm asking jurors, do they know any of the witnesses? Do they know the defendants? Do they know the attorneys? The judge in the lower court stopped the voir dire process for the defendants from asking the jurors, have they seen any media coverage of that? And looking at media coverage, and especially during this time, where there was a ton of media coverage, can persuade jurors that they may not like the defendant and could be prejudicial. And it absolutely is reversible error to not allow an attorney to ask about media coverage on something like this bombing, which got a lot of coverage.
One of the issues that came up was juror number 286 during voir dire. This is the guy that turned out to be the jury foreperson. The defense asked him about his social media. On Twitter, he had allegedly called the defendant a piece of garbage. The judge did not allow that questioning to even begin, really, and that is a big part of it. Another one denied that this individual was having a chat on Facebook where a friend said, just play the part to get on the jury. The defense was not allowed because this judge didn't see that the social media investigation into the potential jurors was worth it, saying that we're going to take these jurors at their word. If they say they can be fair and impartial, then they're coming on this jury. And that was the big problem here. Kira, social media has changed the game, has it not, in terms of getting to know these otherwise fairly anonymous people, the pool of jurors. You can see who they are if you get into their feeds and their social media feeds. You can get a pretty good idea, can't you?
Yes. I mean, I think you can get an idea of who they present themselves to be. And I think that's an important to be able to see into what they really believe. Because, there are many instances where people post things just for reaction, right? So you want to actually be able to go into those questions, in voir dire and be like, hey, let's talk to you about this post that I saw that you had about this. Oh, that was just a joke or something. You can actually go into there. No, that's something I truly, truly believe in. So yes, social media has definitely made it, I don't know if I'd say harder for us lawyers, but we have to do more legwork in that terms of research, both in jury selection and, of course, in the defense or prosecution of whoever our clients may be.
Richard, if it came out that a potential juror had yelled, "You're a piece of garbage," to the defendant, it'd be bounced right away. What's the difference between putting it on Twitter and screaming it at somebody? And it seems obvious that this should have been part of the process.
The only difference there was that at the end of that statement, the judge would then say, well, can you still be fair and impartial? Now, as a defense attorney in a capital death penalty situation, I am not going to take any chances, and I'm going to ask that juror be struck. for cause, and that he or she not serve on the jury. It's absolutely imperative that you understand and be able to question a juror about their prejudice, about their beliefs, because you need an impartial jury. You need the jury to hear the evidence and not be prejudicial against your client. That's how the American justice system needs to work.
Kira, this was a federal case moving the trial. It's a different ballgame, isn't it, than in a state court where maybe a small community. Expense is a big part of a decision to move a trial. It's not a big problem for the federal government to conduct the trial, move it from Boston to another city in the country with a different set of jurors, because let's face it, this was huge news in Boston. This was the Boston Marathon. They just ran it this week. And the whole country, yes, watched it and was in awe and shock and just absolutely affected. But it was those people in Boston that were really affected. Was this a horrible decision looking back for this case not to be moved, especially when you factor in what, Oklahoma City and other issues where they have moved federal cases?
I think there's always an argument to be made to be kept it there, right? So that's where the instance occurred. Those people want justice. Yes, it's a federal case. You don't have that cost issue. Was it a terrible decision? I mean, looking back, if they had been able, what if they hadn't been able to get a fair and impartial jury? What if everyone was so biased that they tried to select that it was something that they couldn't do? I don't know if I could just straight out say like, no, you should have moved it and you didn't. I mean, hindsight's always 20/20, but I could definitely see there'd be reasons why they would keep it. But with what actually happened in the trial and not being able to question these jurors or voir dire, then of course now we look back and say, well, you should have just moved it. That would have helped fix a lot of things, not have as much social media media coverage from that local standpoint, and still get a fair and impartial jury.
Richard, what happens in this case could have ramifications like every case that is in front of the high court. The decision today, the arguments are today, the decision that the court makes will set precedent once again and could be a big one in terms of these questions that come up all the time in cases across the country, pretrial publicity, how to deal with voir dire.
Absolutely, and I think the Supreme Court is going to weigh in on whether or not, despite not asking these particular questions about social, or not allowing defense attorney to dive deeper into social media related questions about what you post on social media, whether that ultimately led to the prejudicial decision against the defendant. So we're going to look at that. I mean, obviously, the First Circuit thought that the lower court erred and should have allowed defense counsel to talk more about what was said on social media and dive a little more in voir dire. So let's see if the Supreme Court agrees. Obviously, if the Supreme Court agrees, that's going to be the law of the land. And that's going to be cases that we're going to use as defense attorneys to ensure that we conduct a proper voir dire.
And those arguments coming up in about 50 minutes, top of the hour. We'll listen to them together live right here on Court TV. Coming up next, as the Ahmaud Arbery murder trial approaches, the Glynn County Court ramps up for jury selection. They'll be going through voir dire next week. Jury notices sent off. Julia Janae, she's there live for us in Glynn County. We're going to get a report from her coming up next. Welcome back. The high-profile murder trial of Ahmaud Arbery is set to begin next week, and court officials in Glynn County, Georgia, are gearing up for jury selection as 1,000 residents were mailed jury duty notices. Defendants Gregory and Travis McMichael armed themselves and pursued Ahmaud Arbery in a pickup truck after spotting the 25-year-old running in their neighborhood. Also standing trial is William Roddy Bryan, a neighbor who joined the chase back on February 23, 2020. Bryan took cell phone video of Travis McMichael shooting Ahmaud Arbery at close range with a shotgun. Court TV legal correspondent Julia Janae is in Brunswick, Georgia, following the trial and has details on the search for jurors. Julia.
This jury questionnaire, one of the largest summons the clerk in this area here in the city of Brunswick, Georgia, has ever sent out for a trial, saying that it's typically 100 to 150 that they send out. But for this high-profile murder trial that is happening in less than a week, it has gone out to really 1 in 84, or 1 out of every 84 residents of the Glenn County area. There's about 84,000 people here, 1,000 summons that have gone out. We're expecting that the jury pool is going to be a bit smaller. There are going to be several locations that the court is going to be questioning this jury pool in and whittling that number down until they get to a total of 12 to sit on this jury plus alternates. Now here's a look at some of those points that have been brought out in the jury questionnaire. It asks how much they know about the case from any source, and it rates from 1 being nothing to 10 being a lot. They're asked to just judge how much they know about a case that has really permeated through this area as far as the media coverage, not only here but nationally. They're also asked if they've done any active research of this case, whether they have gone looking for information not only in the news or in social media. And they also ask if they have commented on this case in the news or on social media. And here's another point and theme in this 3-page questionnaire. Have you visited the Satilla Shores neighborhood since February of 2020, where this all happened? And they also ask if you've seen the video of the shooting in Satilla Shores, asking how many times and where they saw that video. In talking with the family of Ahmaud Arbery, even before the media coverage in this case, just because this is a smaller community, the aunt of Ahmaud Arbery, Kimberly Cummings, said that her co-workers and her boss all knew about the fact that her cousin had been killed. Here's her describing that day and how her boss was connected to the incident location.
I said, I'm going to go on to lunch and kind of call around and see what's going on. One of my daughters worked at the hospital. She said, well, Mama. I said, what? She said, where you at? I said, I'm right here not too far from the courthouse. She said, you heard anything about Quez getting killed? I said, no, I did not. She waited for his body to come in there, because she don't want to go back there and look at his body and stuff like that. She goes there. My daughter does. She goes back there and look at him. She said, Mama, if it is true, they ain't bringing me here yet. So they waited a long time to even bring him there. She waited around. She said, Mama, it's about time to get off now, so I'm going to go ahead and go home. And when she called me back again, she said, Mama, they never did bring Quez. We need to find out what's going on. When it happened, my boss that I work for, she said exactly right around the corner where it happened at. And she said, Kim, tell me it's not true. She said, can you get into this truck with me? And I could give you. She came in her truck with her. She said, I'm going to show you exactly where it happened at. I got there and I broke down crying right. She said, that's when they killed two nephews. It wasn't no home invasion.
We've been getting reports of people who have received these summons and say that they have asked for an excusal, turning that into the court here. That issue of knowledge going to be a big one that these attorneys will be able to parse through, and they'll be able to look at the social media accounts of these potential jurors because they were asked to put that on this sheet. Reporting in Brunswick, Julia Janae, Court TV.
Our thanks to Julia. Defense attorneys for Travis Alexander are expected to present a case of self-defense. Greg and Travis McMichael, sorry, not Alexander, had reason to chase Arbery, would be another defense, saying that they were simply just trying to enact a citizen's arrest, that this individual was in their neighborhood. But prosecutors strongly opposed that and aimed to show jurors that the defendant's pursuit of Arbery was unjustified. A piece of evidence that could help jurors decide for themselves, of course, will come from the police body camera footage, which was taken after just a few moments after that fatal shot was last fired on February 23rd, 2020. Take a look at some of that.
The following video includes graphic content. Viewer discretion is advised.
It's going to be a black male, middle of the roadway. Looks like about mid-20s.
You're watching the initial moments when officers arrive on scene after Ahmaud Arbery was shot and killed in Brunswick, Georgia last February.
Dispatch, tell squad, come on in. The scene's secure.
Yeah, it was just a damn melee, you know.
What we can't show you, but is captured on the police body cam video, are the heartbreaking images of 25-year-old Aubrey dying. He's taking his last breaths as blood flows from a chest wound. Everyone here clearly believes that Aubrey is dying, and very little can be done to save him. Only one officer renders aid, which he explains to the paramedics when they arrive.
It's like shotgun slug to the center chest. He was on his stomach when I got here. I rolled him over. He stopped breathing a couple of minutes ago. It was obvious to me. I told my dispatch 10-7, but he took his last gasp a couple minutes ago. I had pressure on it, but there was nothing I could do.
A few minutes earlier, Aubrey was alive, being chased by Greg McMichael and his son Travis. Neighbor William Roddy Bryan is also in pursuit, according to prosecutors, recording it all on his cell phone. One of the officers first on scene recognizes Greg McMichael, who had recently retired as an investigator in the DA's office. Greg McMichael's experience in local law enforcement appears to play a role in how he and Travis are treated at the scene. At one point, Greg tries defending his son.
He had no choice, man.
Then the elder McMichael can be heard consoling Travis, assuring him that it wasn't his fault.
I had no choice.
Both Greg and Travis would go on to explain what they claimed led to Ahmaud Arbery's death.
We've had break-ins and my gun stolen. And we caught him the other day, and the dad was outside and saw him running by, and the neighbors pointing and everything. So
saw who running by?
Him.
Okay.
So we run out to stop him to talk to him. He took off running. He came over here. He stopped. He come out of the truck running at us. I told him stop till he hit me. I had nothing to do. There's nothing else I can do.
William Roddy Bryant also tells his version of what happened.
And Travis really can't get away from him, can't pull up with the shotgun. I think Travis even gets a lick or two in. And the other black guy gets another lick or two in. And about that time, the shotgun gets raised up, and he pulls the trigger.
As the questioning goes on, the body of Ahmaud Arbery lies on the road a few feet away. Eventually, captured on the body cam video, his body is covered up with a sheet.
This is horrible. When you look at the juxtaposition of Ahmaud Arbery's dead body there, and these guys talking about him in that way. But yeah, that's what happened, and that was captured. And the video will be a part of this trial. All of the video, from Roddy Bryant's cell phone video to the dash or cam and body camera video, the jury will see it and decide for themselves. Still with us, criminal defense attorney Kira Lynn Abernathy and trial attorney and civil rights attorney Richard St. Paul. Richard is in New York. Kira's in Atlanta, Georgia. Richard, the jury selection process in a high-profile trial is always difficult. You've got to look out for stealth jurors, people that want to get on for their own reasons, that know everything. How important are these questionnaires, these extensive questionnaires for the attorneys?
They're extremely, extremely important. And as we can see here versus the court that's being argued, the case that's being argued in the Supreme Court, the attorneys are allowed to ask about social media. They're asking for their particular accounts so they can review those and ask questions on them. This is extremely important to get an impartial jury, especially in any trial case, because you want everybody to have, the prosecution and defense to have a fair opportunity to present the evidence to an impartial jury and let the jury make a decision based upon the evidence that they hear. That's the utmost foundation of our legal system and why we impanel jurors and not just leave it up to a judge. So this is the utmost important in these particular cases, to have a fair and impartial jury.
Kira, this case has really emphasized the importance of body camera video. We saw it with we've seen it now, a steady stream of this, because departments across the country have implemented body cameras. It's down to a science. They're entered into the record on trials that now surface on Court TV. This one in particular, you get the confessions or the statements from the defendants right there. There's really no need to put any of these men on the stand, is there? Even Travis McMichael, who is claiming self-defense, he might be the outlier, but these other, Gregory and Roddy Bryant, they told what was on their mind to the police right away, and so if you're defending him, it's the body camera video, as disturbing as it is, it's kind of good, isn't it, for the defense in that it gives them an opportunity to explain what they say happened?
It gives you a preview of it. So yes, from the sense of like, hey, this is what happened right after the events. This is what they said happened when confronted with police. You know, hopefully as the defense attorney, that's what you're going for, right? Hey, it was in self-defense. You know, you had no choice. This is what happened. But then at the same time, you know, what about what the prosecution presents in their case? Are you going to need to combat that directly? Or is there going to be called into question, you know, the truth of the statements made right after the event happened? And so in that regard, it may be, you know, it may be with the talking with the defendants and saying, hey, you know, you have this right to not testify. We have all this body cam video, but XYZ happened in the case. You know, what do you want to do? And giving them that option. Obviously, it's always the defendant's choice to do that and their right to do that. But it does help give a preview of it, those statements immediately after what happened and when talking with law enforcement.
What is also unique about this case is that people can watch the video of Ahmaud Arbery being chased down that was recorded by Roddy Bryant and have different thoughts on it. When this video was released, it was released by the defendants and their teams thinking that this would exonerate them. They were shocked that the country watched it and the country was appalled. Here's Wanda Cooper Jones, the mother of Ahmaud Arbery, talking about when she found out there was a video.
I can't remember the exact dates, but there was another article that came out and said that they had footage of Ahmaud. And once I learned that, being that it happened in Glenn County, I started reaching out to the investigator who first made the phone call, because if he was present there, I knew he had access to that video. So I found out his contact information, and I began to call him. And he did call me back in about 4 or 5 days. And I told him that I understand that there was a video and I want to see it. And he explained again that the case was still under investigation and I could not see the video. They didn't really share with me what the video was, and the impression, what I was getting at, they had a video that showed Ahmaud actually committing a crime. I was not aware that the video was the video of Ahmaud getting murdered. It was Tuesday, May 5th. I received a phone call from my attorney who told me that the video was out there. And unfortunately, that my brother, who stays in Iowa, he was taking his first break of the morning, and he happened to go on social media, and he saw his nephew being murdered.
Richard, the idea that there's so much that went wrong here. There were prosecutors, there were investigators that saw the video right away because Roddy Bryant says, I have it all on video. You see that on the body cam. He shared it with everybody. They saw that. They didn't press charges. They didn't think that the video showed anything wrong, and yet when the country saw it, it was a completely different reaction. Is there a chance that the jury is split on this?
Look, there could be a chance. Obviously, jurors are human beings, and part of what you're doing in trial is you're interpreting video, right? So what you see is not always a slam dunk, for example, because there could be, at the end of the day, there are still three defendants, and if one of them testifies or not, we don't know, but we certainly have their statements on video that can be played that interpret the events that people are seeing on the video. And if one defendant talks about how Mr. Arbery grabbed the gun and he thought, therefore, and the attorney interprets that as to take it from him and then turn the gun on him, a juror can say, well, maybe he feared for his life. So a lot of it is open to interpretation. At the same time, you certainly shouldn't be trying to chase somebody down the street with a gun. I mean, that's ample opportunity to call the police because you're not the police. They had ample opportunity to call the police, hey, we're following somebody. We think they did something, can you pick them up? Especially that when this guy, one of the defendants has ties to the district attorney's office. And lastly, it's an interesting twist here where you have a prosecutor's office who is essentially being prosecuted for ignoring this case. So the prosecutor in this county is basically under scrutiny and under investigation for initially ignoring the evidence and not making any arrests and not pursuing this. So that's a very interesting twist you don't see very often.
Yeah, DA Jackie Johnson facing charges for her conduct in the aftermath of the death of Ahmaud Arbery. Coming up, the public now has a much clearer picture of what happened to Gabby Petito, the coroner, and the case rules her death a homicide and has specifics on how he believes she died. That is next. Welcome back. The coroner who conducted Gabby Petito's autopsy is revealing disturbing new details in her homicide case. Teton County Coroner Dr. Brent Blue says the 22-year-old died by strangulation. He also reports she died 3 weeks to 4 weeks before her body was found on September 19th near the Grand Teton National Park in Wyoming. Lauren Steinbrecher explains what other critical information the coroner released.
It was perhaps one of the biggest pieces of information not released until now.
We hereby find the cause and manner of death to be the cause, death by strangulation, and manner is homicide.
Gabby Petito was strangled to death as she and her boyfriend, Brian Laundrie, traveled across the country in Gabby's van. Teton County, Wyoming coroner Dr. Brent Blue couldn't release much beyond that in the 22-year-old's murder, except one other important detail: the timeline of her death.
I can tell you that DNA samples were taken by law enforcement, and all I can tell you about remains is that the body was outside for 3 to 4 weeks.
Investigators recovered Petito's body September 19 near Grand Teton National Park, about a week after her family reported her missing. According to Dr. Blue's 3 to 4 week estimation, that means Petito likely died sometime between August 22nd and the 29th. It appears the couple stayed in Salt Lake City August 24th, with Gabby's last Instagram post on August 25th of these photos in Ogden. If she was still alive on the 25th, according to Dr. Blue's timeline, she would have been killed less than 4 days later. Laundrie returned home to Florida in Petito's van on September 1st. Dr. Blue couldn't say if Petito was killed where her body was found in Wyoming or if she suffered any other injuries.
We are only tasked with the determination of cause and manner of death.
Laundrie is a person of interest in her death, and the FBI issued a federal arrest warrant. He hasn't been seen in almost a month.
Let's bring back criminal defense attorney Carolyn Abernathy in Atlanta, Georgia, and trial attorney and civil rights attorney Richard St. Paul. He's in New York. The Petito family did not comment after this revelation. Obviously, they were told this before the media and the public. But Brian Laundrie's family attorney did release a statement, and it says, Gabby Petito's death at such a young age is a tragedy. While Brian Laundrie is currently charged with the unauthorized use of a debit card belonging to Gabby, Brian is only considered a person of interest in relation to Gabby Petito's demise. At this time, Brian is still missing, and when he is located, we will address the fraud charge pending against him. Kira, why release that statement if you're the family attorney for Brian Laundrie?
I think they're trying to say, we don't know where he is, so don't look at us. We're offering all this lovely rhetoric so that way you don't think we had any part to play with his not being able to be found. That's the only thing I can think of, that they're trying to kind of mitigate any future accusations.
Yeah, well, I don't think it's going to work. Richard, it's one thing you don't want to help out, but to take that extra step as an attorney to try to repair, I guess, the image of your client. The day that the autopsy results come in that this young girl was strangled seems a bit tone deaf to me. Maybe I'm wrong. What am I missing here?
I don't think you're missing anything in this. And I think that, talk about adding fuel to a fire. I think that was completely unnecessary. I mean, look, I get it, but I don't get it that, you want to preserve Mr. Laundrie's good name. Well, let's talk about that when we find him. I think the statements were fine where they said, well, we don't know where he is and we're cooperating and we hope that he's found safely. I think you leave it at that. I don't think you need to come back in here and add fuel to the fire to this, especially after the autopsy report, which says that there was a homicide and that death was by strangulation. That's certainly not the type of statement as an attorney for a family that I would advise you make.
Yeah, I mean, everybody, when you find out Gabby Petito was strangled, the first thought was, oh, I wonder if Brian Laundrie strangled her. In fact, that question was asked at the press conference with the coroner. Probably not the right person to ask, but here it is.
Do you have any doubts it's Brian Laundrie?
I can't make any comment about any suspects because we are not involved in that part of the investigation. We are only involved in the investigation of the body of the deceased. So who committed the homicide is really to be determined by law enforcement.
Obviously, he wasn't going to get an answer there, but Kira, that's the thought. What will they get from Gabby Petito's body? They said DNA was taken. There could be something, right, forensically, even though this period of time has passed between when they located her body and when the estimated time of her death is. There could still be something there, could there not?
Yes, there could be, depending on where the body was, how it was preserved, if there was a struggle and if DNA was taken, is it DNA of the person who killed her? And they're not going to release any of that right now, especially if they have a person of interest who they want, Brian Laundrie, that they want to talk to. They're not going to release that at all. But there are definitely things, and I'm not a forensic scientist by any means, but there are definitely things that they could have that could help narrow down who that, the person who did this is, even if it doesn't, have bright neon signs saying it was so-and-so.
Yeah, and we will wait and see. The bottom line is Brian Laundrie is still missing and has not been found despite the efforts of law enforcement and the general public, who everybody has been looking for that young man. Still ahead, 5 juveniles accused of killing a Nashville musician. The youngest suspect in this case, just 12 years old. Details next. Welcome back. 2 teenagers have pleaded guilty to second-degree murder in the killing of a Nashville musician. His name is Kyle Yorlitz. On Tuesday morning, the oldest suspect, Diamond Lewis, appeared before a judge where she accepted a plea deal of 25 years. The other teen charged in the case, Decorius Wright, pled guilty to second-degree murder as well and will serve 26 years in prison. Both Lewis and Wright were tried as adults, despite being just 15 and 16 at the time of the crime. Our affiliate, WTVF, takes a look back at this case that sent shockwaves throughout this community.
There has to be something positive come out of this scenario, and hopefully at least it'll make some changes in that aspect.
This was never the reason the Yorlitz family wanted to visit Nashville. A court hearing for the teens who are accused of killing their son, Kyle Yorlitz, shot in the arm. An autopsy revealed the bullet penetrated his chest, hit his heart, and killed him.
When these young adults made a decision to senselessly murder my son, they also made the decision that they no longer wanted to be a part of a civil society. It's our obligation and prerogative as a society, through the judicial system, to honor that request permanently, whatever that may entail.
5 young people were arrested and charged, the youngest 12 years old. The 2 oldest, 16-year-olds Decorius Wright and Diamond Lewis, face the most serious charges and could be tried in adult court. Decorius is accused of pulling the trigger of the gun that killed Yorlitz. His defense attorney argued that Decorius could only receive the help he needs in the juvenile system. The prosecution pointed out that would mean Wright would get out when he was 19. The defense of Diamond Lewis spoke with us after her hearing. Diamond's attorney says his client shouldn't be tried as an adult because she didn't pull the trigger.
If I was judge, I would want to know that the child was not the shooter personally. And when you get across the river to the criminal justice system, it doesn't matter anymore. But I believe it matters here in the juvenile system that she's not actually the one that pulled the trigger.
That's an outcome that no one from Yorlitz's family wants.
If it was your son, daughter, wife, husband, or loved one, what would justice be to you?
Kyle Horan, News Channel 5.
That piece, of course, filed before the plea deals yesterday. Here's a look at the moment in court yesterday when 17-year-old Diamond Lewis entered her guilty plea on one count of second-degree murder.
Set to go to trial in this case on October the 25th, but today we're here because you've entered a plea, or you've done the paperwork to enter a plea on this on one of these charges. Is that correct?
Yes, ma'am.
Okay. Now, I have a petition that you have signed, and we've had this, the date on this, it says August, it had it August the 4th of 21, but it probably was supposed to be October, and it's now, however, October the 12th. I just want to make sure this is what you still want to do, okay?
Yes, ma'am.
You've signed this paperwork previously, correct? Is that yes?
Yes.
Okay. It tells me you're going to be pleading guilty to a charge on count 2 of this, where you were charged with first-degree premeditated murder. You're going to be pleading guilty to second-degree murder, which is a knowing killing of another, and it's going to be 25 years at 100% service. In other words, your range of punishment is such that it's 25 years, and you're going to have to serve those 25 years. You will be getting your jail credit, which I believe started on the February the 7th of 2019. Is that correct? You've been in custody that period of time?
Yes, ma'am.
Okay, so you'll get that jail credit, but you'll be moving on to the Department of Corrections. So is that your understanding of the agreement?
Yes, ma'am.
Okay, and when we talk about 100%, that's the release eligibility. You're going to have to serve the 25 years. There is some small amount of good and honor time that you can get, but it is not very much. But that's going to be up to you. At this point, you need to think that you're going to have to serve this 25 years. Do you understand that?
Yes, ma'am.
Now, the remaining counts that you had are going to be dismissed as part of this plea. So you're only going to be pleading guilty to this one count. Was that your understanding?
Yes, ma'am.
Still with us, Carolyn Abernathy in Atlanta, Georgia, trial attorney, civil rights attorney, Richard St. Paul in New York City. This case is one of those heartbreakers because you have so many lives ruined. The victim in this case, this musician in Nashville, he's dead. And these kids, there was one as young as 12 that was there that day. These were 15 and 16-year-olds at the time. Now a couple years have passed. Kira Lynn, the way that the system deals with juveniles varies from state to state, but this was one of those cases that was over the line in terms of the level of the offense. The argument was made from the defense attorney that she didn't pull the trigger. She was there, but she didn't pull the trigger. And he sort of made this, saying this in juvenile court, that matters. Up on the other side of the tracks, it doesn't matter in adult court. What is the difference there in terms of the culpabilities and just the way the system deals with an individual from juvenile to adult when you're talking about being an accomplice and not the shooter?
Definitely. You want to look at all the factors. So the judge, in deciding whether or not to keep it in juvenile court or as in this case, she ended up pleading guilty as an adult, is my understanding, that they want to see, it's not just what you did. It was, and how old you were, it was how much you were involved. So even if, as a sort of defense attorney had tried to argue, even if she didn't pull the trigger, the facts, the judge is going to look at the specific facts, going to look at the specific age and say, okay, well, yes, you didn't pull the trigger, but, here's all the reasons why you need to be tried as an adult, because our justice system, we need justice in this matter. Like there's only a certain weight given to how young you are and how much you know and how much life you have left versus, it's very, very tricky in that standpoint. And I think here, hopefully that, the family, at least of Kyle Yorlitz, believes that justice was served here with this plea deal, which I'm sure they were consulted prior to the state accepting it and presenting it to the judge.
There were 5 defendants in all. You saw that 3 of them were ages 12 to 14. The 15 and 16-year-old tried as adults. The other 3 tried as juveniles. They will, as you see there, 5 teens, 3 girls, 2 boys in all, 12 to 16. The 12, 13, and 14-year-olds will be tried as juveniles, and they'll be out at 18 and 19. The bottom line, Richard, this is just a heartbreaker all the way around for everybody involved. Those families of those kids who made that horrible decision, also very difficult for them as well.
Yeah, and it certainly is. And one of the things that, about murder, obviously, is that you can't get the person's life back. And for someone who's very young, not fully developed, they're going to spend, if they're convicted, they're going to spend a lot of time in jail, if not the rest of their lives before they even begun it. So it's a tragedy on both sides. And we know, statistically speaking and scientifically speaking, that young people make poor decisions because they're impulsive a lot. And the question begs, should juveniles be charged with felony murder? That is, in the commission of a murder like burglary, an adult who didn't pull a trigger or kill anybody is going to be charged with felony murder, even though they didn't kill that individual. Now, should juveniles be charged with the same thing? And there is a school of thought that juveniles shouldn't be charged with felony murder if they didn't kill anybody during the commission of a felony. And I think that certainly is some thought that needs to be given out to prosecutors and maybe a change of law, because it is pretty severe for someone who made a poor decision in involving themselves in the felony, but didn't kill anybody or didn't know anybody was going to get killed.
Yeah, food for thought, absolutely. Richard St. Paul, thank you for your time this morning. We really appreciate it. We're going to step aside, take a break. When we return, oral arguments from the United States Supreme Court. Stay with us. Live as we approach the top of the hour. In just a few moments, the Supreme Court will hear oral arguments, and we're going to take you live as soon as those arguments begin. On the docket today, the justices will be reviewing a lower court opinion that wiped away the death sentence for Boston bomber Dzhokhar Tsarnaev. He was originally sentenced to death in 2015 for the 2013 deaths of 3 spectators and a police officer who were killed from 2 shrapnel bombs near the race's finish line. Tsarnaev planned and executed this bomb, you remember, with his brother, but his brother died in a gunfight with police. Let's bring in Kira Lynn Abernathy in Atlanta, Georgia. So what happened here is the appeals court said he needs a new trial, not a guilt phase trial, but just the penalty phase trial. So the high court today is going to listen to both arguments. The federal government is going to argue that he doesn't need another penalty phase trial. And what should we be listening to here as we listen to these arguments that can be kind of highbrow? And there's a lot of cases that are cited and the rest of it. But if you listen carefully, you can really pick up on the different themes. What are you going to be listening for, Kira?
I am listening for the questions that the Supreme Court justices ask, because that tells me where they're coming from. What information do they want to know? Because they've read the briefs, they've read, everything filed beforehand. They're up to speed. They're there to question the attorneys for both sides and say, why should we agree with you? What do you have that we can hang our hat on in terms of prior cases or other law or anything like that? And what do you have that we can agree with you for? So as I listen to their questions, which seems like they always give both sides just, put them through the ringer, I'm listening to see, okay, what is important to them in order to determine whether or not the lower court did correctly or incorrectly, whether, he should get a new penalty phase or not, whether, whatever needs to happen and what they are trying to get into, because like you said, it's very highbrow. They are very, very, very knowledgeable, smart, intelligent people with great staff.
Please the court.
Absolutely. All right, let's go in. Arguments beginning now.
Respondent by himself personally placing a shrapnel bomb behind a group of children at the Boston Marathon. The jury in this case returned a nuanced verdict, unanimously recommending capital punishment for that specific deliberate act. The Court of Appeals should have let that verdict stand. Instead, it unearthed a previously unmentioned supervisory rule to invalidate a careful and lengthy jury selection process that a prior panel had praised. That process reasonably favored individualized voir dire over focusing every prospective juror on pretrial publicity through rote content questioning that would have been unhelpful. The Court of Appeals then again usurped the district court's discretion by insisting that the jury had to hear unreliable hearsay accusations against respondent's brother by a dead man with a powerful motive to lie. We'll never know how or why 3 drug dealers were killed in Waltham in 2011, and none of respondents' evolving theories justifies inserting that separate crime into the penalty phase proceedings for respondents' own individual participation in the 2013 Marathon bombing. And even if the Court of Appeals had identified a misstep in one of the hundreds of judgment calls that this complex trial required, any error here was harmless. The experienced district judge impaneled an impartial jury which heard overwhelming evidence about respondents' own actions and motivations and rendered a sound judgment against a motivated terrorist who willingly maimed and murdered innocents, including an 8-year-old boy, in furtherance of jihad.
Mr. Fagan, one question before you get too deep into your argument. What tests should we use? The First Circuit said that it was exercising its supervisory authority. What tests should we use to review that exercise of authority or to limit that authority?
Well, I think there are 2 separate questions there, Justice Thomas, that the court would need to consider, and deciding either one of them in our favor or deciding that the application of the rule was harmless error would result in a judgment in the government's favor here. But the first question reviewing the supervisory rule is whether the Court of Appeals had the power to enact the rule at all, and the second is whether this court, exercising its own supervisory power, would find that rule reasonable. As to the first question, I think the fundamental problem with this rule is that it divests district courts of discretion that this court has repeatedly insisted that they have over jury selection. If you look at, for example, page 424 of the court's decision in Moomin against Virginia, the court emphasizes that not only in constitutional review, but also in exercising supervisory power over the federal courts, it has given district courts wide discretion over jury selection because they're there and they can see the jurors as they're individually questioned and are also familiar with local conditions. As to the second inquiry, I think the main point here would be that although such questions can be helpful in some cases, they're not invariably helpful, and the district court had sound reasons for thinking that they would be unhelpful here. I'd also note that on the third point I made, Justice Thomas, that the Court of Appeals in devising this rule clearly has a prejudice inquiry built into it. That's clear from page 60A of the petition appendix. That's consistent with the one supervisory rule that this court has made in this context adopted by a plurality of the court in Rosales-Lopez. It's why the Court of Appeals left the guilt verdict in place here, and I think the same analysis ought to apply to the penalty phase verdict. You had a 2-year gap between the events and the trial. Most of the publicity, as the Court of Appeals acknowledged, was factual. Most of it related to guilt, which respondent in fact conceded. The jury was repeatedly admonished to disregard pretrial publicity. There were questions on the 100-page questionnaire that went to any potential bias from pretrial publicity, as well as the sources and the amount of pretrial publicity that each prospective juror had seen. There was follow-up questioning in the individualized voir dire about that particular question, question 77, with virtually every prospective juror and all the seated jurors. None of the seated jurors expressed a predisposition to impose a capital sentence, which is the only thing at issue.
All that makes sense, but I'm looking more for the standard that you would apply. What would be your rule, assuming you accept to some extent the supervisory authority of the First Circuit? What would be your rule for reviewing the exercise of that authority?
Your Honor, I think if the court accepts that the Court of Appeals can dictate to district courts how to do this, I think this court ought to just be reviewing the rule to see whether that was a sound and reasonable exercise of the rule, bearing in mind that it is an exercise of supervisory power that the Court of Appeals is imposing in a context where district courts have the utmost discretion.
Do you think, would we review it as the First Circuit exceeding its supervisory authority in the sense that normally that authority is exercised, say, on local procedures or something like that? Or are you saying that we should review it in this area for something like reasonableness?
Well, Your Honor, I think you could do, frankly, either. I think at the threshold, the court ought to ask whether the Court of Appeals exceeded its authority in even enacting such a rule. If you look at the court's decision in Painter, it is a clear expression by this court that courts of appeals shouldn't invoke their supervisory power as an end around to the reasoning of this court, which is, I think, what the Court of Appeals has done here. The second way you could look at it, Justice Thomas, is more of a whether, assuming it actually had the authority to do this, should it have done so? And I think if you look at this court's other supervisory rule decisions, where even accepting the Court of Appeals might have had the authority to enact some rules in this area, enacting a hard and fast rule like this that would at least be rigid enough to divest the experienced district judge in this case of his sound discretion to determine that these questions wouldn't be a helpful addition to the mix of information already available to the parties, and that it could be addressed through individualized voir dire, and that the questions might even be counterproductive by focusing the prospective jurors on something that the judge was at the same time instructing them that they should disregard. To the extent the rule is that wooden and that rigid, it is an unreasonable supervisory rule, Justice Thomas.
To go back to the beginning of your answer to Justice Thomas, do you dispute the authority of the courts of appeals to issue some requirements under their supervisory power?
Certainly not as a general matter, Your Honor. I think it's a little bit more circumscribed when it comes to jury selection procedures because of this court's repeated emphasis on the discretion that district courts necessarily have to have.
Where does that authority come from?
Your Honor, we're following this court's cases which appear to presume that this court has some supervisory power and haven't especially...
Well, our supervisory power would be different than the Court of Appeals' supervisory power over district courts, right? Are you just, because we've assumed in some cases that courts of appeals have it, relying on our precedents?
Yeah, Your Honor, we haven't questioned whether courts of appeals generally have supervisory power. I suppose one other way to decide this case in the government's favor would be to take issue with that, but we haven't questioned that specifically.
Mr. Fagan, if we took question with that, it would upend a whole bunch of rules, some of which in Moonbeam itself we endorsed. But there are local rules about making sure that a pro se prisoner knows that he or she, what rights they're giving up if they're going to proceed pro se. There are local rules on what you have to do if you're going to dismiss a complaint, letting pro se litigants have an opportunity to cure their deficiency. We have local rules on waivers of all kinds, including jury waivers. There's a whole lot of local rules that talk about what courts are thinking about as adequate process. And they're not changing outcomes. They're just saying to courts, before you exercise your discretion, make sure that these things have happened.
Well,
so are you suggesting that we should take aim at those local rules?
No, Your Honor. Let me just emphasize two quick points. As I emphasized to Justice Barrett, we haven't questioned the Court of Appeals supervisory
So why
authority in
in
this
Mu Ming, I think it said, did we spend, I think, 2 or 3 paragraphs talking about local rules?
Well, Your Honor, the other point I was going to make in response to your original question before I get to that specifically is we're also not questioning, I didn't take Justice Barrett's question to get at the separate issue of, for example, local rules that district courts enact for themselves. However, in Mu Min, the court did note the existence of some supervisory rules in this context. There might be a question as to how far each of those rules at the time of Mu Min would have extended and whether they would have covered this case. But I think the reasoning of Mu Min, again, I'd point the court back to page 424 of that decision, makes clear that in exercising its own supervisory power, this court has not dictated specific forms of questioning, even in the most sensitive context of race with the supervisory rule adopted by the plurality in Rosales-Lopez. I think it was inappropriate for the Court of Appeals here to have a rigid wooden rule that dictates specific questions.
It wasn't all that rigid. The rule was very simply stated in Patriarch, which was ask some questions about the kind and degree of publicity that's out there. And the court permitted degree. It permitted people to tell how much they had read, a little, a lot, or a moderate amount. But it didn't permit questioning as to what kind of publicity, because there was a whole lot of different publicity here. There was publicity on the day of the event. There was publicity the days after. There was publicity about what major politicians and others were suggesting the punishment should be. There were interviews of victims. There was a whole lot of different kinds of publicity. And the district court and the government objected when counsel attempted to elicit that kind of information. That seems like an extreme control over trying to figure out whether someone could have been influenced by that publicity.
Well, a few points, Justice Sotomayor. First of all, the government did not always object, and if you look at pages 733 to 735 of the Court of Appeals appendix in this case, you'll see the district court emphasizing that these questions would be allowable on a juror-specific basis, depending on the kinds of answers the juror had previously given. As to the different kinds of publicity, Justice Sotomayor, they didn't request any questions asking whether jurors had seen specific types of publicity. And I think the reason they didn't do that is because they didn't want to focus the jurors on those kinds of things, like what opinions people might have expressed about the death penalty.
So what was wrong with the one question they wanted to ask? What stands out in your mind about all that publicity? It seems to me that that's not asking for details of everything you've read, but what has influenced you or affected you enough for you to remember it?
Well, I think
that seems like a totally appropriate question to me.
I think as respondents' own counsel pointed out, and this is at page 480 of the joint appendix, a question like that is unlikely to be particularly useful in a case like this because everyone saw the same coverage, so they were all going to say the same things. The carnage at the finish line, the chase in Watertown, the killing of Officer Collier, the boat manifesto.
Well, doesn't it tell you something, someone who says something else? How about if you ask a juror that and the juror says, I listened to victim X, and that has haunted me. That certainly would be information relevant to a defense attorney and even to the prosecution.
Well, Your Honor, I think I'd push back a little bit on whether on the idea that there wasn't questioning that got at the kinds of publicity that the jurors had seen. Many of the jurors volunteered such information. There were occasions when Respondents' Counsel was able to ask that question, or there was some other revelation of some media coverage that some particular juror had seen. The jurors were extensively questioned on their views on the death penalty in particular, and if the jurors were biased on that by something, that might have itself come out in the course of that question.
Mr. Counsel, we call this, or it's been called a supervisory rule. Now, if I'm going to argue a case in a circuit court of appeal, you look at the rules, there's usually a little pamphlet tell you these are the circuit rules. They may be supplemental to the Court of Appeals rules. What makes this a rule? It seems to me that it's really nothing more or less than a precedent. I mean, is there a collection of these supervisory rules somewhere? This is Rule 22? What?
Well, Your Honor, I don't think I'm going to really dispute what you just said. I think everyone was actually taken by surprise that there even was such a thing as the patriarchal rule, given that no one had cited in the district court, including the Court of Appeals itself, when it was reviewing jury selection procedures in a mandamus petition about venue. It praised the jury selection procedures and never once mentioned.
Should we consider this requirement in any way different from the way we consider any precedent because it's labeled a supervisory rule?
If anything, Your Honor, I would give it less weight because it was dictum in Patriarcha itself, which simply affirmed the denial of a venue change. So I really don't think...
If we issue an opinion and we write it and it has a particular holding, I think the author would probably be very happy to say, you know, our rule going forward is this. But that's just saying it's a precedent. I don't know attaching a label to it. I mean, Justice Sotomayor is right. There are circuit rules governing a lot of things. And from minor, you know, filed your application on 8.5 by 11 paper to more significant things. But this is a rule of law. I don't see what's gained by calling it a rule, a supervisory rule.
I agree with that, Your Honor. I think the reason for labeling it such and the reason certain things are labeled supervisory rules is there are advisories going forward to in this instance, district courts to tell them that if they do not do something in the future, they will be reversed for not doing it.
Well, we tell them that too, that if they don't follow this particular rule of law in the future, they'll be reversed. I don't know that every one of our cases governing district court practice is a supervisory rule.
Yeah, I think it is particularly geared toward areas like case management where they're just trying to put district courts on notice. I think that is actually a fairly poor characterization of Patriarcha itself, which, as I said, kind of renders this as something of an advisory note at the end of deciding something else. So I'm not even sure.
Isn't the distinction that it's not based on the Constitution and it's not based on a statute or a regulation? It is a prophylactic rule that is adopted by the court for the purpose of protecting a constitutional right. But it isn't, the proposition is not that this is required by the Constitution. Is that the distinction?
Well, it's not. I think that is one distinction. It's not required by the Constitution. The court's drawn that distinction in this particular line of cases where it's been somewhat stricter in reviewing federal courts than it has been in reviewing state courts. That's quite clear from for example, Moomin. And if one accepts that courts of appeals can impose their own supervisory rules in this context, I think what they're labeling a supervisory rule is just, as I was telling the Chief Justice, just an advisement to district courts that this is how you should do it. But I think it definitely exceeds a Court of Appeals authority